Good evening, everyone. Welcome to our Law Excellence's unique initiative, Current Affairs for Beginners. Before starting the session, first we need to apologize you because in this video I am going to cover both yesterday's and today's topics. But we assure you from tomorrow onwards, we'll provide you that day's topics on the same day itself. Now let us see answers for the questions from a previous video. With regard to prepaid payment instruments, consider the following. Prepaid payment instrument sector is regulated by Securities Exchange Board of India. This statement is incorrect because it is regulated by the Reserve Bank of India. And closed system payment instruments do not allow the withdrawal of cash. This statement is correct. Whereas open system payment instruments will allow withdrawal of cash. An example for this is credit cards and debit cards. So as only 2 is correct, the answer here is B. Which statement given above is or correct? So it is only 2. The next question is how purchasing managers index is different from the index of industrial production. While PMI is a monthly comparison, index of industrial production is compared to the same month of previous year. That means that if IIP of 2018 December, it will be compared with 2017 of December's index. Whereas this PMI is a monthly comparison. 2019 January index will be compared with 2018 December with the previous month's performance. Whereas the next one is while IIP indicates the actual output, that is the actual industrial production, whereas the PMI will indicate the expectations of the firms because it is nothing but a survey in the form of questionnaire, whereas IIP is the actual output, that is the industrial output. So as both the statements here are correct, the answer is C, both 1 and 2. And these are our today's mains questions. You can answer them in our www.CivilsPrep.com website. Now let's start our today's session. These are all the topics that we are going to cover in our today's video. Our first article is Supreme Court shocked as Section 66A of IT Act is still invoked. This article comes under GS paper 2 under the topic of governance, and here the subtopic is government policies and interventions for development in various sectors and issues arising out of their design and implementation. From this article, first let us see what is the context of this article. The Supreme Court has issued a notice for an application that was filed by People's Union for Civil Liberties. This has filed a petition in the Supreme Court on the basis of there is a continuous usage of this section 66A of IT Act, in which it had submitted that more than 22 people have been prosecuted under this provision even after Supreme Court has scrapped this section in 2015 itself. Because Supreme Court has felt that this particular section is invading the right of free speech under Article 19 Clause 1 Clause A of the Constitution. Because this act was considered as a draconian law as it has led to arrest of several innocent persons, which has added fuel to public agitations. So the Supreme Court has struck down this particular act as unconstitutional by saying that it is invading the right of free speech under Article 19 Clause 1 Clause A of the Constitution. Now let us see what is this section 66A is all about. According to this section defines that punishment for sending offensive messages through a computer or any other communication device like a mobile phone or tablet. A computer or a mobile phone or a tablet. So this particular section will give power to the government authorities to issue directions to block public access of any information through any computer resource. This act will directly give the authority so that they can block any information, not only an offensive information. And it also allows the authorities to arrest a person for posting allegedly offensive content on websites, leading to imprisonment for a term that might extend till 3 years along with fine. But this section has been misused because it led to the arrest of many innocent persons. So the Supreme Court in 2015 in Shreya Singhal versus Union of India, in this case it has struck down this particular act as unconstitutional. The next article is Lok Sabha passes Citizenship Bill amidst Congress walkout. This article comes under GS paper 2 under the topic of polity, and the subtopic is Indian Constitution, historical underpinnings, evolution, features, amendments, significant provisions and the basic structure. So from the prelims point of view, what is important from this article is we should know what are the key features of the bill and what is the Citizenship Act of 1955 and what are the ways to acquire citizenship in India. First, let us see some background. We know that India has single citizenship and there is no dual citizenship. A citizen of India is a citizen of all Indian territories. This feature is a unitary feature which is in contrast with double citizenship that is available in many countries. For example, in USA, a citizen of US can be at the same time be a citizen of California or other states. This single citizenship also reflects the social and political conditions that were created at the time by partition. During communal rights, many Hindus and Muslims they migrated to Pakistan and also from Pakistan to India. At that time, it was felt it is necessary to respond to the situation that was created by lots of refugees from Pakistan. But our constitution, it didn't codify permanent laws for citizenship and it has given the responsibility to the parliament. By using the powers of Article 10 and 11, the parliament has enacted Citizenship Act of 1955. This act mentions the ways in which a person can be an Indian citizen. That is, by birth, descent, by registration, by naturalization and by incorporating the territory, incorporating a new territory. And according to Article 9 of the Constitution, a person who voluntarily acquires the citizenship of any other country can no longer be an Indian citizen. But citizenship by descent, persons who were born outside India on or after January 26 of 1950 but before December 10th of 1992, they are considered as citizens of India by descent. If the person's father was a citizen of India at the time of their birth. But from December 3rd, 2004 onwards, persons who were born outside of India will not be considered as citizens of India unless their birth is registered at Indian consulate within 1 year of their date of birth. And in Section 8 of the Citizenship Act of 1955, if an adult makes a declaration of giving up of Indian citizenship, if any adult, if they want to give up Indian citizenship and they want to go to some other country, then also that person will lose Indian citizenship. Now, what is this illegal immigrant? According to this Act of 1955, an illegal immigrant is a person who will enter India without any valid passport, or if the person stays in the country after the expiry of visa permit, and the immigrant who uses false documents for immigration process is also known as illegal immigrant according to this Citizenship Act of 1955. Now, what is this amendment? Why they want to bring change to this Act of 1955? This bill wants to allow illegal migrants from some minority communities in Afghanistan, Bangladesh and Pakistan who were eligible for acquiring Indian citizenship. In other words, it wants to amend this act by allowing the illegal migrants, which was not permitted by this Citizenship Act of 1955. And this amendment bill is also saying that it also has a feature: the registration of overseas citizen of India card holders can be cancelled if they violate any law under this amendment. And this bill will allow, as I said, that certain minority communities belonging to Hindu, Sikh, Buddhist, Jain, Parsi and Christian religious communities coming from Afghanistan, Bangladesh and Pakistan. These illegal immigrants from these three countries, they were not supposed to be imprisoned or deported back in their countries. And this bill also had a feature that the minimum year of residency in India to apply for citizenship according to our Citizenship Act of 1955 is at least 11 years. This act wants to reduce it by 6 years for these migrants. One thing that has to be remembered here is this bill doesn't have any features. That means it doesn't extend to illegal migrants belonging to Muslim community. And it didn't even mention or about any other minorities in the three neighboring countries like Jews. The next article is 10% reservation for the poor gets Lok Sabha approval. This article comes under GS paper 2 under the topic of governance, and the subtopic is government policies and interventions for development in various sectors. And there is also another subtopic under which this article will fall: welfare schemes for vulnerable sections of the population by the center and states. So from this article, what we need to study is what are the proposed amendments and who are all the population covered under this bill. What is the context of this article means? The Union Cabinet has approved the proposal for introduction of Constitution 124th Amendment Bill, which will extend 10% quota to the economically weaker sections in the general category who were not covered by any of the existing schemes of reservation. The bill is designed to amend the constitution by extending 10% reservation in direct recruitment in government jobs and for admission in higher educational institutions to the population who are covered here is economically weaker sections among all castes and communities. Here Christians and Muslims were also included. As I said before, it is covering the people who were not eligible under any existing schemes of reservation, that is under any existing quotas. And this bill has defined who are economically weaker sections. According to the bill, a person whose annual household income is below 8 lakh rupees and if they have agricultural land below 5 acres and a residential house which is below 1000 square feet, and if the residential plot below 100 yards is in a notified municipality, or if the residential plot below 200 yards in notified non-notified municipality area. This is the criteria that is defined by the bill for an economically weaker section. So what needs to be done to bring this quota, to make this quota a reality? It needs an amendment of 2 articles. One is Article 15 and the other one is Article 16 of the Constitution. Article 15 talks about prohibition of discrimination on the grounds of religion, race, caste, sex or place of birth. Whereas Article 16 tells about equality of opportunity in matters of public employment. And as this is a constitutional amendment, it should be ratified in both Lok Sabha and Rajya Sabha by at least 2/3 of the members present and voting, and also by the legislatures of not less than half the states. Why it is needing a constitutional amendment? Because Constitution has mandated a reservation. It has kept a cap of 50% reservation. Now this 10% reservation will be in addition to the existing cap of 50% reservation that is available for scheduled castes, scheduled tribes and other backward classes, which will become a total of 60%. So this quota will target the poor among the upper caste, and this will be over and above the 50% mandated by the Constitution. Therefore, it needs a constitutional amendment bill. The next article is quota questions. This is an extension to our previous article. From this article, now we are going to see what is this Indira Sahani case. A 9-judge constitutional bench of Supreme Court in Indira Sahani case of 1992. It has answered a question whether backward classes can be identified only and exclusively based on economic criteria. Then this constitutional bench has ruled that a backward class cannot be determined only and exclusively based on economic criteria. So the bench has held that economic criteria can be a consideration in addition to social backwardness, but it should not be the sole criteria for providing reservation. The next article is Lok Sabha passes DNA Technology Bill. This article comes under GS paper 2 under the topic of governance, and the subtopic is government policies and interventions for development in various sectors, and it also comes under GS paper 3 under the topic of science and technology. And here the subtopic is awareness in the fields of IT, space, computers, robotics, biotechnology and issues relating to intellectual property rights. From prelims point of view, what is important here is DNA bill highlights and what is the difference between this DNA and RNA. If we see the context here, the Lok Sabha has passed DNA Technology Bill, that is DNA Technology Use and Application Regulations Bill, that will allow regulated use of DNA technology to establish the identity of certain defined categories of persons, including offenders, suspects, and who are under trial. What is the need for this law and what is its importance? The importance of this DNA-based technologies is related to solving the crimes and to identify missing persons. And as this technology, DNA-based technologies were well recognized and were proven useful across the world, the bill wants to expand the application of our DNA-based forensic technologies in order to support and strengthen the justice delivery system of India. Because if we see some of the features of the bill, according to the bill, national and regional DNA data banks will be set up for maintaining a national database for identifying victims in case of any disasters and suspects in cases under trials, missing persons and unidentified human bodies. And also there is a provision if the bill is misused, if this DNA profile information is leaked to people or entities who are not entitled to know the information, that person will be punished with a jail term of up to 3 years and also a fine up to 1 lakh rupees. And this information, all the DNA data including DNA profile, samples and records will only be used for identification of a person but not for any other purpose. And this bill, once it becomes an act, it will lead to the establishment of DNA Regulatory Board, which will accredit the DNA laboratories that will analyze DNA samples to establish the identity of an individual. And it is expected that the expanded use of DNA technology will result not only in speedy justice delivery, but it will also increase conviction rates, which is at present only around 3% according to National Crime Report Bureau statistics. The next article is a renewed attack on privacy. This article comes under GS paper 2 under the topic of governance, and it also comes under GS paper 3 under the topic of internal security. From this article, now we are going to see about two things. One is what is meant by money laundering, and we'll also see about this Prevention of Money Laundering Act. Money laundering, it refers to conversion or laundering of money that is illegally obtained in order to make it appear that it has got originated from a legitimate source. By this method, the criminals, they will conceal, they will hide their criminal activities like drug trafficking, armed trafficking, terrorism. All the profits they have earned through the criminal activities will be hidden by converting that amount which was illegally obtained by making it appear that it has got from a legal source. So, to address this issue, that is to prevent money laundering and to confiscate the property, that is to take away the property derived from money laundering, the Parliament of India has enacted an act known as Prevention of Money Laundering Act. This act has made it mandatory that all the banks, financial institutions and intermediaries, they should verify the identity of their clients and they should maintain the records and provide the information of clients to the authorities. The next article is death traps. This article comes under GS paper 3 under the topic of environment. From this article, now we are going to see about two organizations. One is National Green Tribunal and the other one is Central Pollution Control Board. First, let us see about National Green Tribunal. It is a statutory body established by the government by issuing a notification using the powers of National Green Tribunal Act of 2010. So this body has derived its responsibilities from this National Green Tribunal Act of 2010 by replacing National Environment Appellate Authority. What does this Green Tribunal, National Green Tribunal do? This body is responsible to provide effective and fast or speedy disposal of cases that were related to environmental protection and conservation of forests and other natural resources, including enforcing any legal right that is related to the environment. And it is also responsible for providing relief and compensation for the damages to persons and property. Now let us see about this Central Pollution Control Board. It is a statutory organization which functions under Ministry of Environment and Forests. This organization has derived its powers from Water Act, Prevention and Control of Pollution Act of 1974. But later it has also been entrusted with the powers and functions under Air Pollution Act, Air Prevention and Control of Pollution Act of 1981. So what does this organization do? This will work to promote cleanliness of streams and wells in different areas of the states by preventing and controlling the water pollution according to this Water Pollution Act. And it will work to improve quality of air by preventing and controlling the air pollution in the country as per this Air Pollution Act. And this organization will coordinate the activities of state pollution control boards and resolve the disputes between them. And it is this organization which is responsible to lay down the standards. Based on these standards, the streams and wells has to be maintained. And it will also lay down the standards for the quality of air. The next article is customers cannot be charged for availing tokenization service. This article comes under GS paper 3 under the topic of economy, and the subtopic here is mobilization of resources, banking. From this article, from the prelims point of view, what is important here is the token mode of payment. First of all, let us see what is this. What is this tokenization? It is a process through which sensitive information or data will be replaced with a unique set of characters. That is known as token. And this token will retain all essential information without compromising the security of sensitive information. So in the payment space, tokenization will replace the 16-digit payment card account number with a unique digital identifier which is known as token in mobile and online transaction. This token will allow the payment to be processed without exposing our sensitive account details, which can breach the privacy and security. Now let us see how this tokenization will actually work. We know that our credit cards and debit cards will have our names on it, and it will also have 16-digit personal account numbers on it, and we will also have expiry dates valid through in that mode, and it will also have security code like CVV. So all these details will be tokenized. So when a merchant swipes the customer's credit or debit card, then this personal account number will be automatically replaced with a randomly generated alphanumeric ID, which is nothing but this token. So our 16-digit payment card account number will be converted into a unique digital identifier which is known as token. So our original personal account number will never enter the merchant's payment system. Only this token ID will go. Then the merchant can use this special token ID to keep the records of the customer. This token will get transmitted to the payment processor, who de-tokenizes the ID and authorizes the payment. What are the advantages of this tokenization? First one is data security, because this tokenization will keep our credit card data safe from internal and external threats which can occur during payment processing. And this credit card tokenization will help online businesses to improve their data security. from the point of data capture to the storage, because it is eliminating the actual storage of card numbers in the point of sale machines and also in the internal systems. And the most important thing here is comfort. Multiple tokens will be issued for the same card payment on different platforms that use tokenization. So even a website we use gets breached and the tokens are acquired by the hackers, it is difficult to reverse engineer the actual card number from it, because access to tokenization logic is also needed. Now let's see our today's question. The question is, how is National Green Tribunal different from Central Pollution Control Board? Try to answer this question and we'll see the explanation for this question in our tomorrow's video. And this is our Law Excellence website where you can access the notes for this video, and this is our official Telegram channel where you can access all the other material of Law Excellence. Thank you.